Good morning. I'm Ron Trzynski, real estate agent with Saks Realty. And today I'm going to talk about title. When somebody purchases a home, they know about the house. They know things like, I'm going to probably have to get a mortgage or come up with the cash to purchase it. They perhaps are aware of things like appraisals and inspections. But a lot of people don't think about one of the most important parts of the transaction, which is the services that take place with the title company. And today we're going to discuss what happens with a title company. And of course, we have an expert with us. Charlene Perry is with us from Broadview Title. So Charlene, why don't you introduce yourself and just tell us a little bit about yourself and maybe how you got into this business.
Thank you, Ron. Thank you for having me. It's my pleasure to be here. As you said, I am with Broadview Title. We are based out of Bel Air, but we service the entire state. I've been doing this now for 43 years. So I've seen it all. I've probably heard it all. And title is, to me, very interesting. To some, it's kind of dry. But to me, I love the puzzles. I love the history of every house. You can learn so many things from researching title. The title company's role in the transaction is really to kind of bring everybody together, kind of make sure that all of the pieces are fitting in the right places, kind of keep everybody on task in as much as closing places, dates, times, that type thing. But what we actually do is we research the property to see who currently owns it. We learn who owned it in the past. We learned whether or not there are any open mortgages, judgments, liens, other encumbrances that would in any way impact your ability to enjoy your home without any kind of issues cropping up as relates to perhaps fraud, missing heirs, misrecorded documents, documents that were recorded in the wrong land records. I mean, there's so many things that we find when we do a title search. But as a buyer, what you want to know is, does my seller own the property? Does my seller have any liens against the property that title needs to clear and release prior to my taking title? As a buyer, you don't want to take title to a piece of property that's subject to any liens, because you then become responsible for those liens. So that's not something that you want to do when you're buying a piece of property. Our main role is to offer policies of title insurance to both the lender and to the borrower. The lender requires a policy of title insurance, so that should tell you right away that it's an important component of your transaction. The owner's title policy is considered an optional purchase by RESPA and by lenders and others, but in my opinion, it is never optional. It is something that you really, really have to have to protect your interest in your home for as long as you own your home. And you only pay for it one time. You pay for it at the time you purchase your home. It's not a renewable policy. It just is continuing from the time you purchase your home to the time you sell your home. If you buy the enhanced coverage policy, your coverages increase over the first 5 years to add an additional 20% equity, or rather 20% coverage on that policy. So when you first buy your policy, at the time of closing, you're insured up to the purchase price. But if you buy that enhanced policy, every year for the first 5 years thereafter, you get another 20% bump in that coverage amount. And hopefully, you'll never need it. But if it's there 10 years from now and you have a problem that you need to have a title claim filed on, because you have so much equity in your home now, because the equity has built, your coverages will now meet your needs, hopefully. I will tell you that more often than not, the things that we find most often that become problematic are unreleased deeds of trust. Unreleased lines of credit are a huge problem. HOA liens can sometimes become problematic. So if you buy a piece of property and you don't have title insurance, and 5 years later someone comes knocking on the door and says, hey, I had this mortgage on this home that never got paid off when the seller paid it. You now are responsible for paying this off. Well, if you have a policy of title insurance, you file a title claim. The title insurer takes care of your legal expenses, fights to get the matter resolved, and ensures that you now do have a clean, good, marketable, and insurable title. So that's really the basis of what we do. There's a lot that goes into it. what we start with, obviously, is the contract of sale, which comes to us from the realtor. So the realtor sends us the contract of sale. We review it. We see who the seller's supposed to be. We see who the buyer's supposed to be. And with that, we then start our title search.
When you do a title search, I guess there could be two parts to looking at that. There's looking at the ownership, and there's looking at liens and such encumbrances that may be against the property.
Correct.
Well, let's talk about the ownership of it. Does your firm do that, or do you contract out? I know there are some companies that do an abstract search of the property, which gives the history. And how far back do you go on a typical property?
So the industry standard is between 40 and 60 years, depending upon a number of different factors. In our office, we do use the services of a abstracting firm. We will ask them to do the abstract, and they'll go back at least 40 years, oftentimes more. Depends on how far they have to go back to find the best legal description, or if a problem shows up in, something happened in the 40th prior year and they need to figure out why, they need to go back farther. But the industry standard right now is 40 years. So, but again, in my experience, I see mostly 60 or more.
Where do they find this information?
So we find this information in the land records, the Maryland Land Records, which is a state-based free database website that enables anybody access to enable you to see anything you need to see that has been recorded as it relates to a particular piece of property. Every jurisdiction has its own database. So for instance, if you're looking for something in Baltimore County, you would go into the database relative to Baltimore County. There's a number of different ways in which to begin your search. In Baltimore County, you can begin your search with either the property account number or the property owner. When you pop in that property owner's name, it will tell you anything that property owner has done as it relates to that piece of property from their time of ownership.
So when you say a thing that they've done, so that could mean whether they've gotten a home equity line of credit against it, or if they had to get a permit to build a deck on the back of the house.
So honestly, that's a great question, and I'm kind of glad you bring that up. Permits are not something that we look for, although they are covered in the enhanced owner's policy. That's a separate search. Not all jurisdictions have their permits available online, so we really can't search those. So permits is not part of what we look for, but what we do look for, as you stated, we look for open mortgages, we look for lines of credit, we look for restrictive covenants and conditions that might have been filed as it relates to that community. For instance, if you're in a community that has a homeowners association, we'll be able to go back to see when that homeowners association was formed. We will find then the documents of formation. We will find also declarations of covenants and restrictions, which will tell you, the consumer, what you can and cannot do in that community as it relates to that particular home. Oftentimes, when you are, in fact, every time you're buying a piece of property that is situate in a community that has a homeowners association, it is required that you get a copy of the resale package from the listing agent or from the seller. That resale package will contain many of these documents that we find in the land records. We find these in the land records and then we review them. And if there's anything that glaringly comes up and says, wait a minute, we know that this consumer wants to use this home for this purpose, but we see here in this declaration they can't. Well, that's something you want to know as a consumer. You want to know whether or not you can, as an example, just because it's kind of trendy right now, if you want to have chickens. Some communities don't allow it. So you need to know that. So that's one of the things that we look at. We look at those declarations and covenants, but that's also one of the things that you as a consumer need to look at.
I've seen something happen in homeowner associations, and it's arguable as to whether it's legal or not, but some homeowner associations put into their bylaws that the properties in that development cannot be rented. They believe it will bring the values down, so they only want homeowners. So I guess that's something that an investor would obviously want to know, or somebody who's buying and thinking, I'm going to buy, and maybe somewhere down the line when I upgrade to a bigger house, I'll keep this one as an investment and rent it.
Yeah.
That could quickly spoil their plans.
Exactly. I mean, even if you are looking to buy a piece of property and use it as an Airbnb, for instance, some places will allow for rentals, but they don't allow for short-term rentals. So there's a difference between a lease for a year and an Airbnb. So you kind of do need to know that. So that is one of the things that you don't want to look at. Now, we don't digest it as deeply as that, quite frankly, because we don't have time. But if we see something that's glaring, and we know, because we know the contract, we know whether or not it's going to be a homeowner or whether or not it's going to be an investor, and that pops up at us, obviously we're going to let that investor know, wait a minute, this is maybe not going to work for your needs. You might want to revisit this or get more information to see if there's been some sort of a bylaw change that has not yet been filed, or if there's a meeting upcoming with the homeowners association that speaks to this. So the land records, is where we start, and it provides so much information. I mean, I oftentimes come up with, different things that I find in the land records that, you look at it and you're like, oh my gosh, I can't believe they filed that, document in the land records that says, this property can only be sold to persons. For instance, if you have a situation where there's a boat slip in a community. So you have let's say a condo with a boat slip. You can buy the condo, you can buy the boat slip. So sometimes they're different, transactions. Maybe they don't come together. Do you know what I mean? So you buy the condo, you buy the boat slip. But then in the future, you want to sell the boat slip. Well, in some of those HOA docs, it'll tell you can't sell the boat slip to someone who doesn't own one of the units. So again, that's something else you need to know. So that's why it is so very important to have a title search done, to read the documents, or to at least read the title commitment, which is the document that we present to the consumer, the buyer, in advance of closing, telling them, we've done the research. This is what we find. These are the documents that are recorded in the land records that we find that impact this property. And then the onus will fall, in many instances, to the borrower to look at those documents or to call title and inquire. Well, what did you see? What can you tell me about this document? Can you elaborate? And we're happy to do that. Go through those documents.
So in some cases, I mean, obviously the lender wants to know that everything that's going on. But say in the case of the boat slip, or what might happen, but just as often or more often, there are some condominiums that have a parking space with them, or a garage space.
Garage unit, exactly.
Now, typically the buyer is assuming, especially if it seems to be advertised that way, that parking spot comes with that condo. But sometimes they are deeded separately.
Correct.
And so you would want to make sure that both statements are in the contract.
Correct.
That you're purchasing this condo and you're purchasing this particular parking spot.
Yes.
Because you don't want to get in there. Now, the bank might not care so much.
Right.
I mean, I guess it has some impact on value. But if it didn't have the parking spot, or it did or didn't, okay, well, for the most part, we're giving you the loan on the condo.
Right.
So unless the seller knows and tells you that up front, you don't know, because you don't get the condo documents right away.
Right.
Exactly. Whether you're the title company or whether you're the buyer, you don't see them right away. So you're somewhat trusting that they're telling you how it actually is and that they actually know.
Yeah, absolutely. And that's a very good example. As a matter of fact, I find it happening a lot, where it will be assumed, as you said, that, condominium unit A is being conveyed to whomever, and the assumption is, okay, I'm also going to get that parking spot that comes with that. And then title look at the title deed, and we say, well, wait a minute, the title deed says that this seller owns unit A plus parking spot B. Is it the intention of the seller to convey parking spot B as well? And then we go back to the agents and we say, hey, this is what we find. The contract isn't clear. Please get us an addendum that clarifies this, so that we know from a title perspective what we need to put in our new deed from the seller to the buyer. Is the seller conveying both pieces, or are they only conveying the unit and retaining that parking spot? So those are the kinds of things that we do find as part of our title search.
Another thing that typically I don't think is in the public records, but would be a lease. And probably you don't see it so much on residential. Maybe it's on commercial a little bit more. I know if it's a short-term lease, like I think it's 125 days, they don't have to record it.
Mm-hmm.
So maybe somebody does a rent back,
Mm-hmm.
so they have a lease for that.
Mm-hmm.
But a 1 year or 2 year lease, do you see those out there? Because if somebody's purchasing a property and has a lease, the lease will convey with that property.
Yes, Jen, that is correct. If that's what they agreed to. So residentially, as you said, no, we would not see that unless it was a lease for, I believe, more than 7 years. If it's a lease more than 7 years, I believe they have to record it. We do see it commercially. We see it a lot commercially because oftentimes the lender, if in fact the current owner had to take a loan, they too will file an assignment of leases and rents, meaning that lender knows that you, the borrower, taking on a piece of property that is currently subject to long-term leases for this particular commercial property. So lender wants to know about those. And as I said, if they are more than 7 years, I believe that is correct, those do get recorded. But short-term leases do not get recorded. So it's imperative that the agents advise the parties. Seller needs to advise their agent. Buyer needs to be made aware if, in fact, it's a residential piece and it's being sold subject to an existing lease. That needs to be made known to the buyer because the buyer, once they take title, they then become the owner of that lease. They become responsible for maintenance. Obviously, they're responsible for maintenance anyway, but pursuant to the terms of the lease. And should they choose to do so, to get that particular tenant out, they would have to go through the eviction process because they assumed the ownership of that lease. So, as I said, residentially, we don't see it a lot. Commercially, we do see it.
And of course, the way it is in Maryland, and this may be the case in some other places, you have to assume when leases aren't there, when you have squatters in the house, but that's a whole other discussion.
That's a whole different discussion, exactly. Mm-hmm.
Let's transfer to the other side of the search. We talked about the kind of looking at the deeds, the people end of it. Let's look at the liens that might be against a property. Now it could be somebody has a mortgage. They could have a home equity line of credit. They maybe have HOA or condo liens, so to speak, against it, tax liens against the property. What other kind of liens might there be?
So the other thing that we search for, we do search to see whether or not the current owner has any federal tax liens against them that would in any way impact the not the ownership per se, but they would have to be paid and released to make sure that we're not conveying a piece of property to a buyer that could be attacked by the government as it relates to an existing lien that was against that seller. So we do search for state and federal tax liens. We search for bankruptcies as well. If your seller is in bankruptcy and is trying to sell a home, which certainly they can do. There's nothing to say they cannot do that. But there are certain things that need to be done, certain rules that need to be followed to ensure that the bankruptcy court has approved the sale, has approved the payment of commissions, has approved the contract of sale, etc. So we look at those kinds of things as well to make sure that the seller isn't currently in bankruptcy. If the we also look to see whether or not the parties on title are married. We look to see if they are currently involved in a divorce, which may impact the way in which judgments attack the property or attach to the property. So we look at all of those things as well.
Now with different liens on the property, there's a priority to the liens. Like on an easy case, a first mortgage has priority over a second mortgage.
Correct.
Or taxes generally are before any mortgages.
Correct.
Is there anything that comes before real estate taxes?
The only thing that comes before, well, real estate taxes are kind of their own little animal, but a federal tax lien, a tax lien filed by the United States of America will come before everything. That's kind of a super lien. So
like if someone owed income taxes, and now the person sells their property, the income taxes would need to be paid first.
So they would need to be paid as part of the transaction. Obviously, now
and if there's not enough money to cover those,
then negotiations need to be had. Sometimes you can negotiate. We, from a title perspective, we cannot call the state government or the federal government to negotiate on your behalf. And in fact, you don't want us to, because as soon as we make that phone call, those entities know that you're under contract and you maybe lose some leverage, so to speak, as it relates to your ability to negotiate. I'm not saying that that's an actual fact, but it could be a situation where you just call them and say, hey, I want to pay this lien off. I want to give you 50 cents on the dollar. Can we negotiate something? And, you get involved in these negotiations. And then whether it be state, federal, whomever, just be like, okay, let's start negotiations. And then, oh, by the way, are you selling your home? Are you getting any proceeds? They want to know whether or not you're getting any proceeds, because that has to do with their negotiations with you as to, how far are they willing to bend, kind of a deal. You'll see that sometimes. We don't see it a lot, but we see it sometimes. So yes, there are some super liens.
Now related to this, and kind of just an aside to the discussion, but related, if you start making these calls,
we title?
Yeah, if you made the calls, the question is, even not just related to that topic, but do you represent one party or the other?
We do not.
Okay. So
no, we represent the property.
All the more reason why you even say, we shouldn't be calling anybody. We don't represent you.
Correct. What we normally say is, we don't represent you. You definitely have an opportunity and a right to obtain counsel. We urge you to obtain counsel if you don't understand, just as your contract of sale says on page 1 in very bold letters, if you do not understand this, seek counsel. We urge people to do the same. Seek counsel, because we do not represent you. We actually represent the property and our ability to insure that property. So there's no representation from the title standpoint for one party or another. And that it does become a confusing point sometimes, because people say, well, I'm the buyer. I selected you as my title agent, and, we've run into this problem, and, you should be representing me or helping me with this. Well, we will be happy to help you to the extent that we can, but we absolutely do not represent you in any kind of a legal capacity. We are tasked with conveying clean, marketable, or insurable title. That's our task. And obviously, working together with the lender to meet all of their demands, and to disperse funds, record documents, that type thing. So that's our role. It is not our role to represent. We can put you in touch with counsel. We can give you some resources, but we do not represent.
Speaking of in Maryland, my understanding is that the buyer is the one who has the right to select the title company.
Correct.
So once the buyer and seller have agreed and created a contract to purchase a home, now it's the buyer who finds a title company. There are times where a seller has already been working with a title company. It happens with investors where maybe they had the title company already do some research for them. So they said, we've already got the title work done. We want you to use so-and-so title. Can the seller dictate or only suggest?
They can suggest. They cannot dictate. They cannot condition the sale of the property on that. So they can certainly say, hey, my title agent is very familiar with this title. It was kind of messy when I bought it. They cleaned it all up. They've already got all the back work done. So in order to save time, perhaps you might consider using my title agent for your purchase. The buyer can certainly consider that, and the buyer can certainly make that election. But it's absolutely up to the buyer to choose whomever they want to work with, whether it be seller's agent, seller's title agent, or go out and get their own title agent. And that is actually a statutory matter. It's not something that is negotiable. It's actually written into the contract, if I'm not mistaken. It says that the buyer has the absolute right to select their own title agent.
Right. Well, in the the contracts that are prepared by the Maryland Association of Realtors, it is definitely in there.
Yeah.
Of course, when you deal with investors, they always have their contract. Well, if you want to call them contracts,
Right.
basically on one or two sheets of paper,
Right.
and they don't talk about that stuff.
No, they don't. But it is the statutory right.
Well, yeah. So it's whether it's in that contract or not, it's irrelevant.
Correct.
Because it is the law.
Correct. Yeah.
Now, is it possible for if they've already worked with a title company to say, well, you can use your own title company, but there are going to be some charges because this other title company has done this or that? Or do you say, fine, whatever they did, but you, seller, if you use them, you pay them?
Yeah. So if buyer calls me and says, I want you to do title for me and take care of these title and settlement services for me, and then seller calls me and says, hey, wait a minute, my title agent has everything done. If you jump in, they're going to charge me a fee. Can you, the seller might do that. Can you title, use my title agent's work for your services so I don't have to pay the fee? Generally, we're not able to do that simply because when our abstractors do our title searches for us, they certify them to whichever firm they did the work for. So we can't really just go switching them back and forth amongst firms.
Well, but would an abstract company be willing to say, yeah, we'll transfer it from title company A to title company B?
It has happened, yes.
But we'll charge you $100 for doing that.
It has absolutely happened. It's always a negotiation. And at the end of the day, everybody has the same goal. We want the consumer to get into their new home. We all obviously want to get paid for services rendered, but there are situations, rare though they may be, where the title is just so wonky and so messed up that seller's title agent may have already spent endless hours cleaning it up. And for me to jump in now and start all over again isn't going to make financial sense to the buyer even, because I'm going to have to maybe charge the buyer additional sums of money for additional time, or alternatively, I'm going to have to charge the seller additional sums of money for additional time spent, additional resources needed to be sought. So sometimes we will negotiate and say, okay, fine. In this case, it is better for the consumer to go with seller's title. And that way, everybody wins. The consumer gets what they need. The seller doesn't have to pay extraordinary extra fees. So we do negotiate. Within the industry, we do work well together. Title A and Title B, we do generally work very well together. We try to work in a way that makes sense to the consuming public. We're not at one another's throat. It's not real cutthroat. You know what I mean? We try to all work together, and even to help in title clearance. If I find something in the chain of title and I know that my seller, for instance, bought this home 4 years ago and I can't find a release of a prior old open mortgage, I'll say to the seller, do you have a copy of your title policy from when you purchased your home? Seller may say yes, may say no. If they say yes, great, then I can work with that. If they say no, I say, well, can you tell me who the title agent was? Let me reach out to that title agent and see if I can get more information. And I'll reach out to them and say, hey, look, I'm trying to clear this issue. I can't clear it. Can you tell me how you cleared it? And we'll have a conversation. And oftentimes there'll be additional documents that seller's title might have in their file that they can share with me to help me clear title. So that there is a lot of cooperation.
Now, I started us on a tangent there.
Uh-huh.
So let's get back just to the liens. Where do you find the information about these liens? Where do you go to find out if there's a mortgage or a second mortgage or a third mortgage,
Right.
or over outstanding taxes or HOA document of fees that are owed, and so on and so forth?
Right. So most of those things we do find in the land records. We do find the open mortgages. We do find lines of credit. We do find HOA liens, because those all have to be filed in the land records to be valid and enforceable. As it relates to judgment issues, we use a different resource. We use the Maryland Judiciary, which again is a free public website that is available to everybody throughout the world, I guess, because it's
And
online.
on that is the database, you would search it by person, not
Yes.
by property.
Correct. We would search it by person. So we look there to see whether or not there are any additional liens that we need to address, whether it be a state tax lien, a federal tax lien, or some other type of lien. There are different kinds of things that we look at. So that's an additional database that we search. That is, again, a free searchable database available to the entire consuming public. And it has listings for all of the cases filed in the state. In fact, just in the state.
If a contractor does work on a house, but then they don't get paid, and so they sue to get that money, where is that going to be found? Is that going to be found in the judicial records, or is that going to be found in more in the public records for that property?
So that's called a mechanics lien, and it's going to be filed in the land records. Again, in order for that contractor to secure their lien against the home where they did the work, they have to file that in the land records. So we will see that there as part of our title search. We will see a mechanics lien has been filed, and we will then make sure that we get the payoff statement, get that paid at the time of closing so that the buyer isn't buying into a problem.
Now, before I go to title insurance, I want to cover one other thing that you guys don't do it, but you do typically start this part of the process, which is a survey of the property.
Right.
Can you tell me more about that?
Sure. So as part of our services, we do order or have ordered on behalf of the buyer, generally a location survey. So a location survey is a survey that is basically telling you the surveyor went out to the home and they used the land records information, as well as they did do a physical search of the site, review of the property, to ensure that the house is sitting within the lot and to determine whether or not there are any encroachments onto or off of the property line. Now, location survey will give you a good guideline, but it does not establish property lines. So you can't use it as you would, for instance, a stake survey. But it will give you a good idea as to whether or not the fence encroaches off of the property line or the neighbor's shed is sitting across the line and into your property a little bit. So we bring this to the attention of the consumer and of the lender, if applicable, because the lender will want to know that as well. The title insurance policy that we write to the lender will ensure to the lender that if that shed needs to be removed, you're not going to be faced with that. We'll take care of that. To the buyer, though, because they know about it, title insurance will not protect them as it relates to moving that shed or figuring out that fence line if we're using a location survey, because that's a known matter at the time of closing.
Right. And if there's something on that the title company is not going to cover, we're giving you title insurance subject to this shed being in the way,
right,
or encroaching on the property. Do lenders have a problem with that?
No.
Okay.
No.
It'd have to be something more significant than that for the lender to have a problem.
Lender would likely never have a problem with it, because we write two different policies of title insurance. We write a policy for the lender and we write a policy for the buyer. So the lender's policy will sometimes offer more or further assurances against certain things such as that than would the buyer's policy. That would be a lender requirement to enable them to write the loan. So if there were a shed encroaching from the neighbor's property onto the subject property, the lender, in order to have the coverage for the lender, the title insurance coverage for them, they may say this has to be corrected. No, they will say we need to be insured as it relates to this, meaning that should that ever come to a point where somebody with competent jurisdiction, in other words, a court, should a court say that shed has to be moved, the lender's interest in that title is not impacted. The title insurer would cover them. A lender's policy, we have to remember too, it has a number of different coverages that are not necessarily in the owner's policy. Again, we do write those two different policies, although they are basically the same. We will sometimes offer further assurances, as I said, relating to such issues, perhaps as that shed. It will specifically say, we do discover, lender, that there is an encroachment of this shed. Should that be forced to be removed by a court of competent jurisdiction, your policy of title insurance will cover you, lender, against the costs and expenses incidental to that removal. However, that will not appear in the buyer's policy because we knew about it at the time of closing, and we do not insure that. Again, we do not insure that for the buyer because we already knew about it.
Okay. Now, before we get too deep into the title, let's finish off the survey stuff. Do lenders typically always require that the buyer have a survey?
They prefer it, but it is not required more often than not. If, and there I have to put these caveats, if title will write the lender's policy insuring them against matters of survey without benefit of having a survey, the lender will accept that. So will title issue that policy to lender without benefit of a survey? More often than not, in a residential transaction, in a community that's on a plat, for instance, yes, we will. So yes, lenders will accept that piece of property without benefit of a survey. Commercially, no, never.
When do you find where buyers don't ask for a survey?
Cash. If you're paying cash for a piece of property, more often than not, a buyer does not want a location survey. They don't feel it necessary for whatever reason in their, discussions with title, their agents, whomever, or their review of the property, and they'll say, I don't want one, and that's fine.
In townhouses and row houses around the Baltimore area, the lots are so obvious as to what the dimensions are, especially if it's
On a
if all the backyards are fenced
Yep.
and such. That some people think, well, it's pretty obvious where my property lines are.
Right.
I got a street in the front, I got an alley in the back, and it's a rectangular lot.
Right.
Usually they're correct.
Yeah.
That there's not much more to it than that.
Mm-hmm.
Now there was, not too long ago, I was looking at a property in Baltimore City. It was the second house in from the corner.
Mm-hmm.
Now the owner happened to own the corner lot and the second one. And maybe, I don't know if this owner did it or some owner who owned both properties. Behind the house, they put in a garage and another building. Those buildings went over to the second property.
Mm-hmm.
So I was asking one of the people when I was looking at it, I said, well, who owns these buildings? I said, oh, well, that's not part of we were looking at the second house.
Right.
I said, oh, that's not part of that one.
Gotcha.
Of course, when I pulled up the plat, it clearly showed
The lines.
the rectangular lot where those would have been imposing on that lot.
Right.
So no, we didn't get the contract for that one, but if we did, I would have thought we definitely want a survey. I want to know what's what here.
Absolutely.
And we're going to claim that garage.
Right. I mean, that's a bit of an unusual situation, a little bit more complicated, but in those cases, absolutely, you're going to urge your client to acquire a survey. And in that case, you're going to want them, in fact, to acquire a meets and bounds, or not a meets and bounds, a stake survey. So that it can be absolutely determined, where does this inside unit property line start versus, this outside property unit, and how much of this shed is sitting here, and what are we going to do about it? Are we going to ask the seller to move it over onto his lot? Or, exactly how are we going to negotiate with that? Because, that would be a problem.
Yeah, and then if you get past the row house and start looking at individual houses, sometimes those lots are very basic also, and it's obvious where the boundary lines are.
Yeah.
But sometimes, especially if someone puts up a fence or certain things appear to be part of the subject property, you think, oh, well, maybe we don't need to survey. We can see what the boundary lines are.
Right.
But maybe the previous owners were related.
Right.
And they put a fence up and they didn't care that the fence went over the property line a little bit. Yeah, that's my fence. Yeah, well, that's on my property.
So oddly enough, yes, I appreciate your question, and it's a good question. As it relates to fences, when the surveyor goes out to the property,
They say good fences make good neighbors.
they don't know who put the fence up. They can't know who owns that fence. All they can tell you is this is where the fence sits. And then on the survey, it'll often tell you so they give themselves a little bit of wiggle, and they'll say, the accuracy rate is, plus or minus 1 to 2 feet. So they sort of define the fact that we didn't go out and find pins and markers. This is what we see on a visual. There is a fence that appears to encroach onto or off the property line. We can't determine who owns the fence. So fences are hugely problematic when it comes to, well, who owns it? And more often than not, it's easier just to ask the seller, who put that fence up?
If an appraiser goes to a house, and then of course he's not doing the survey, but the appraiser goes to the house and is told, yes, the fence is part of it. They calculate that into the value.
Okay.
But now if the survey comes out and says, oh, that fence is not on this property, now you say, okay, if the appraiser gave that house $5,000 because of this fence that went around the whole thing, and he finds out that a large portion of it isn't even on that property,
right,
I would think that affects the appraisal, which then affects the loan.
That could become problematic, absolutely. But again, the surveyor makes a notation. The fence appears to be off the property line by X, but there is a variable of whatever the variable is that they're using on that survey, plus or minus, 1 to 2 feet or whatever. So again, it's visually noted on the survey, and we send that over to the lender, and then it's on the lender to determine, together with their appraiser, what they want to do about that or whether or not that's going to impact. But yeah, that has happened. Absolutely. It's rare, but it does happen for sure.
If someone does not get a survey, does that impact the cost of the title?
No.
Okay.
So speaking of cost, as it relates to title insurance, in Maryland, title insurance rates are filed with the state. So if you call me and ask me for a quote for title insurance, I will give you that quote based on the state filings. If you call another title agent and ask them for a quote, they will give you the exact same quote because we have to.
Now, and there are only so many companies out there that provide title insurance in the area. Is that correct? Is it like limited to like 3 companies or so?
So we have to define what we're talking about. I am an agent of a title insurer, no different than your automobile agent is an agent of, as an example, Allstate. If you file a claim, you call your agent, but your agent isn't paying that claim out. Allstate is.
Right.
You follow? So if you file a claim on title, you call me and I say, okay, I'll help you with this claim. And I reach out to whomever, whether it be First American, Old Republic, Fidelity National, whomever. Those are the entities that pay out the claim, that pay your legal fees, that assist with title clearance and that type thing. The rates are all the same, essentially all the same. They may be off, $1 or $2, depending upon which title insurer has filed those rates, but they're all pretty consistent. And yes, like you said, there are a handful of major title underwriters that are working in Maryland. I think there's about 5 major title underwriters working in Maryland. So, and most of them are nationwide. I don't think we have any regional underwriters in Maryland right now.
We start looking at title insurance now. A lender is going to always require
100%.
Okay, but if it's if someone's buying without a loan or it's a private loan, then they might it's not required.
Correct.
How often do you see someone forego title insurance?
Not very often, really. Probably less than 1%.
And I've seen where people get the title insurance, but there are certain exceptions in it. Is it worth it to get title insurance when there are exceptions in there?
Absolutely. Exceptions are things that we find in the land records that already exist. Basically, we find condo docs, we find agreements with BG&E to allow them to come in and maintain the lines. We find agreements with Public Works to come and maintain the water sewer services. Those are all things that are considered exceptions. So in other words, if you own a piece of property, somebody comes digging up the dirt to maintain a sewer line, you can't call and say, hey, title, they're digging up my sewer line. What's up with that? Well, look at your title policy and it'll tell you that they have a right to do that because there is an exception there. They had already filed in the land records this right to do this pursuant to this agreement. So those are the things that are considered exceptions. There is no rate difference per se as to whether or not there's exceptions or no exceptions.
But if there were a lien against the property,
Yeah.
that wouldn't make sense to have an exemption for a lien against a property.
No, absolutely not. And that's why we do the title search, because we don't want you, the consumer, to purchase a piece of property that is subject to a lien. We would then be tasked with clearing that lien on title before conveying the property to you and before writing that title policy. So the only time we would ever write a title policy subject to a lien, you, the consumer, would have to agree to that. And it would be highly, highly unlikely that we would ever be tasked with doing that.
Yeah, I had a home that I was selling for someone, and when title did their search, they actually found that there were liens against the property, which were not from that particular owner.
From a prior owner.
It got all complicated
It happens every day.
Well, there was the one guy I dealt with, he died, so his wife took it over. But the guy that I dealt with also had an investor with him. Okay. He wasn't on the name; his name wasn't on it. But everybody thought there's no way that he would have done this with those liens against this.
Right.
So, well, we got it sold, but it was like, how did that happen?
You'd be surprised. I mean, we run into situations all the time where we have an elder family member who has now died, and their children are coming in to sell the home, and we call them and we say, hey, mom and dad had a line of credit on the home, dating back to 1982. We need to get that released. And they'll be like, well, I have no idea what you're talking about. Well, research now needs to be done because we cannot convey subject to that line of credit. Lines of credit, unlike regular deeds of trust, are perpetual unless released. So we have to make sure that those get released. Those are some of the biggest issues that we have day after day after day are these lines of credit. So it happens a lot where the seller really had no idea what was, that there may have been something there that needed to be addressed until it's brought to their attention as part of that title search that this matter does exist. So then research has to be done. Family members have to dig through paper. Yeah, it happens a lot.
Title insurance for the lender, I think the cost of that is typically higher than it is for the individual, or have I got that backwards?
So customarily what happens is the policy of title insurance that we will write both a lender's policy and an owner's policy. The owner's policy is cost whatever, and then if you're getting both the lender's and the owner's policy together, there's that simultaneous issue cost. So it's sort of a blended cost. I can't explain it better than that. Without showing you the schedules, but there's sort of a reduction in the total cost if you're buying them both at the same time. Now, if you're just buying a lender's policy, that's a cost. If you're just buying an owner's policy, that's a cost. So if you're just buying an owner's policy, you probably don't have a loan because you don't need that lender's policy.
And those are generally not cost prohibitive.
No, not at all. I mean, let's just say that, and again, I don't have any of the schedules in front of me, obviously, but let's just say that you're buying a piece of property for $200,000. Your title insurance premium may be $1,400. I'm just kind of throwing a number, so don't write that down in blood or anything, but that $1,400 is a once and done. You pay for it one time. You pay for it at the time you buy your home. If you live in your home for 10 years, it costs you $140 a year, I guess, is a way to look at it. But you never get a renewal notice. You never get another bill. You're always protected. You're always covered. If you own your home for 30 years and something pops up in year 29, you are still covered for that same one premium.
Now, if you don't get the enhanced insurance, it covers you for the purchase price of the home.
Correct.
If you get the enhanced coverage, it will say if the value of the home was 100,000, it will, for 5 years it will increase how much it covers by
Correct.
what, 5% per year.
I think it's 20.
20?
But I'll have
Okay.
to look
Well,
it
that's
up.
pretty good.
But yeah, I'll look it up. I mean,
that fits in with the recent appreciation of property
honestly,
rates.
You know what? I look at these policies every day, and I do need to look at that. So let me clarify that one. But it does increase for the first 5 years. Yes.
Okay, but if you own a home for 20 years, odds are your home is going to be worth more at that point in time
Yeah.
than what the policy covers.
Yeah.
But if you've had it for 20 years, odds are nobody's stepping forward with any kind of claims against that house.
Hopefully.
Yeah.
Right? I mean, yeah, hopefully. But that's why you have a title search done, because things can be missed.
Which is the next question I'll ask, which I would think a buyer would ask this. You guys did the search. Now I
Right.
got to have insurance. It's kind of like when I go to the hardware store, I buy a lawnmower. Oh, and do you want this warranty?
Yeah.
Why? Didn't you sell me something that's good in the first place?
Right. Yeah. That's a good analogy. I like it.
So, well, tell me about that.
When we are working with the land records, we have to be reminded that the people who are entering data and scanning documents into the land records are humans, and mistakes can be made. So if they're doing data entry and they enter my name, Charlene Perry, on a particular piece of property, and they inadvertently enter it in the land records in Baltimore County, but my property sits in Harford County, title isn't going to find that in a Harford County land record search, because it's been recorded in the wrong land records. It's been recorded in Baltimore County.
Or even worse, if it sits on the line.
Yeah, exactly. We've had that happen as well. But so mistakes are there. There are mistakes in the land records. There are documents that have been misindexed, meaning we can't find them when we're running our indexes, when we're running names or property addresses or whatever, because they've not been indexed properly. There are mistakes in spelling that makes it such that we don't see it. So things do happen, and it's, much of it is related to human error. And that is, in fact, one of the biggest reasons why you need title insurance. We can't tell you what's not there. We can only tell you what is there, what we did find.
So if somebody had a lien against their property to whomever, but they didn't record it,
Mm-hmm.
that is something that could pop up. Or isn't there some law that says you have a lien for so much money, you have to record it?
There may
Be
well
nice.
be. I mean, I should have started off our conversation by reminding you that I'm not an attorney, but
Right. No, neither am I. Just
Right.
so everybody knows that. Neither
Right.
of us are attorneys. We just play them.
yeah, no, we don't. We do not play them. We make a phone call to our attorney.
Which is another thing. Everything that's done through your title company, there is an attorney
Yes.
who is on staff.
Absolutely.
And so it all goes through the approval of the attorney.
Absolutely. Yeah, we are absolutely. In fact, in my office, we are blessed with one of the best attorneys that I've dealt with over my career as it relates to real estate matters. Not all attorneys are very well versed in real estate. It's a specialty field, and there's lots of nuance. So yes, but all title agents do have an attorney either on staff or available to them in some fashion. Because oftentimes we do have questions that are, in fact, legal questions that I can't answer. I'm not an attorney. I can't answer your questions in any kind of a way. If it's a legal question, I have to reach out to counsel.
Right. And I know we've had discussions before about things, and you have given me tentative answers, but said, I will research that for you.
Right.
And part of that research, of course, is talking with the attorney.
Yes, absolutely. We lean heavily on our attorney to make sure that the information that we're providing or the guidance that we're trying to give is consistent with what the law says. But getting back to your question about whether or not there's some sort of a law that requires somebody to file a document in the land records, I don't know that it's a law, but it certainly makes sense. If you want somebody to know that you have a valid lien against a piece of property, then you should absolutely file that in the land records so that it's able to be found, so that you get paid at some point in time if those people ever go to sell the home.
One of the things, and this brings up another thing that can come up in the title search, which didn't used to be necessarily recorded out there, and this is very much a Maryland thing, is ground rents.
Oh, God help me.
And there was one other thing that's in there, and this is a more recent thing. What a builder would do in order to offset the cost of the
Water sewer hookups.
the water infrastructure for a development, they would have that as a separate fee, not in the taxes and not paid for in the cost of the home, but a separate fee that typically, I guess it would be paid through the homeowner association if there was one, but or however it would be paid, where you'd be paying that separately. In some counties, you can find that on the record. I think in Baltimore County you can. Harford County, my understanding is that's not in their public records, or whatever. It's not necessarily you're not necessarily going to find it in the public records.
I would disagree with that assessment.
Well, maybe they've changed it. I mean, that's what I've been told.
Water sewer facilities charges, those charges that you were just referring to, where the builder is tasked with laying the infrastructure and connecting into the county water sewer system, those documents have to be recorded in the land records in order for the monies to be essentially guaranteed to be paid, because they impact every lot owner. So they have to be recorded. And as a matter of fact, water sewer facilities charges, if filed correctly in the land records, are a lien in front of a first mortgage. So they actually have a priority.
Similar to taxes.
Similar. They actually have priority, and that's relatively a newish piece of information, newish within the last 8 or 9 years, having to do with a lawsuit that was filed, which was protracted, blah, blah, blah. But so they sort of have a super lien, but they have to record those documents in the land records. And yes, you can find them in the land records. Is it easy? Not always. Can you just go type in water sewer facilities charges? No. You have to go digging. You have to look at all of the documents that are filed to see if they are those documents that relate to those public works hookup fees, or not public works, but you know what I'm talking about. So yes, you will always find those in the land records, whether it be Baltimore County, Harford County, Howard County, whomever. They have to be there, or they don't have an enforceable lien. And those liens go on for 35 to 40 years. And they follow the property for 35 to 40 years. So the builder is not going to neglect to file that document, because they need that money to be coming in to offset their original expenses. So they're really likely not going to neglect to file that. Can it be filed in the wrong place? Sure. Can it be indexed wrong? Sure. Can it be hard to find? Absolutely. But should the seller know that it exists? Yes. So we kind of start there. We go to the seller. Hey, looks like this community is newer. Is there this fee that you pay every year? Oh, yeah. That gives us kind of a clue. If we can't find it for whatever reason, okay, it's filed under this particular entity, or this is the servicing entity, we'll search that. So there's a number of different ways in which we do our searches, but you'll always find those.
I had one house, and it was not that long. It was last year where we sold the house and had this situation with the infrastructure, sewer infrastructure cost. The owner, the seller, had not paid, wasn't not up to date, and he had all intentions of paying it when we sold the house, but then we could not find
the servicer.
Right. So, we had some names, we had some addresses, and actually I was tracking some of these places down. One place I went, nope, he's not here. Another place I went, well, no, he isn't here, but if you find him, let us know, because we keep getting mail for the guy. In fact, usually it was a server has been here with looking for him.
Wow.
Okay, that doesn't sound good.
No.
But we couldn't complete the sale until we had that resolved.
Yeah.
Which eventually we did find them.
But, well, that's good. Yeah. It can be difficult sometimes.
And what we couldn't do, because we suggested this is how much hasn't been paid. Can we create an escrow account? Wasn't allowed.
No, because you have to escrow the entire amount that is due for the entire period of time. So, for instance, as you well know, there's...
Well, like if he had paid for the first 10 years.
Yeah.
And then he didn't go for 5 years.
But we can't know that.
Well, if you don't know, if you can't find the people.
Yeah. We can't know that. And since these things run for 35 to 40 years, we would have to hold that entire amount in escrow plus any overages for legal fees, expenses, that type thing.
Well, let me ask you about the other one that I had just mentioned, the ground rent. A registry was created in Maryland, and at first they said, okay, you don't have to register.
Right.
Didn't make a lot of sense.
Right.
And I think it's still, you don't have to register.
Only if you want to get paid.
Yes, if you want your money. Well, I have a house right now. We knew it had one ground rent, and then title said, oh, you have a second ground rent. Oh, gee, do we? Which I still have to put, that could be another discussion, but I still have to question the legality of there being two ground rents.
It happens.
This.
You can have a lease and a sublease. That's an absolute.
Well, in this case, it didn't appear to be a sublease. So, but that's
whichever one's filed second is sub.
Well, or at least takes second priority to the first one.
Yeah.
But it's if they had not, what I look for is it on that registry? Because if it wasn't on the registry, then I think we could have made the argument, oh, you didn't register it, you're not getting paid.
You're not getting paid at closing. Not that you're not getting paid.
But after a certain period of time, don't they lose the right to collect that money?
No. The ownership of ground rent, if you own a right to collect ground rent, you are the fee simple owner of that property.
The ground rent holder.
The ground rent holder. So keep in mind, when I'm researching title, I'm researching the dirt. I don't care what's sitting on the dirt. I'm researching the dirt and what has happened to that dirt or with that dirt from the time of its inception into a community to today's date, whether that be 300 years ago or 50 years ago. You know what I mean? So the person who owns the right to collect that ground rent has an actual right in that real estate. You can't just go snatching it away. And that's been litigated again and again and again and again over the years.
But isn't the magic number in years, 20 years, if you can prove that they have not been collecting the ground rent for that period of time?
There is a provision that says that you can, within your deed, if you're the seller, you can say, I've owned this home. I have owned this home for more than 20 years. During that entire time period, I have never received a bill. That you could arguably then say the property is fee simple. But you have to be the owner for that time period. It can't be you owned it for 10 years and I owned it for 10 years and I called you and said, Ron, did you ever get a bill? And you said no. And I said, well, me neither. So that's 20. That's not 20.
Has to be one contiguous set of years from one owner.
One owner. Correct. It doesn't happen often. It really does not, because most people don't stay in their homes that long. Relating to the ground rent registry, if your property is registered and you have not been paid, you can claim up to 3 years backwards of payment and get those monies collected at closing and then, bill out in the future to the new owner if your property is registered. If your property is not registered and you come crawling out of the woodwork, as happens sometimes, a family member won't know that a deceased family member owned that fee simple right to collect that ground rent. They'll come crawling out of the woodwork and go, hey, you owe me ground rent for the last 20 years. Well, they can't do that. They can only collect the ground rent if it's not registered for the time period from when they came popping their little head up. So the registry gives them that 3 year. They can collect for 3 years past.
Okay. Well, let's get past ground rent because nobody likes those anyway.
It's very complicated.
Let's change the topic. Let's go to deeds. Mm-hmm. Who prepares the deed? What's in the deed? Who signs the deed? And when you're doing your research and you look at old deeds, are there ever any things in there that can impact the sale?
Absolutely. So this discussion could take hours, but let me try to finesse it. When we look at deeds, we're looking to see who owns the property. We're looking to see how they own it and how that ownership interest impacts the transaction. In Maryland, there are 4 types of ownership rights. You can either be a sole owner, you can be tenants in common with somebody else, you can be joint tenants with somebody else, or you can be tenants by the entirety with your spouse. Mm-hmm. Depending upon how you own the property has to do with how you can sell the property, or how you need to sign, or who needs to sign. So if you're a sole owner to the property and you're the seller, so in all of these scenarios, I'm talking about the seller. You're the seller, sole owner, you sign the deed. Title prepares the deed as part of the closing process. So title will have you, Mr. Seller, sign the deed to transfer the title over to whomever the buyer may be. That's sole owner. If you're a joint tenant with somebody else, title, again, would prepare the deed. We would have both joint tenants, or however many joint tenants there are, sign the deed to convey the title over. The difference between a joint tenancy and a tenancy in common has to do with rights of survivorship, and we'll get into that in a second. Again, if you're in a joint tenancy situation, all joint tenants have to sign the deed. If you're in a situation where you're husband and wife and you're tenants by the entirety, both husband and wife have to sign the deed in order to convey the entirety of the estate over to the new buyer. Why it matters is whether or not somebody dies. So if you're a tenant by the entirety with your spouse and your spouse dies, you are now the owner as just a matter of fact. By operation of law, you are the sole owner now because you have those rights of survivorship. If you are a joint tenant with somebody, those same rights of survivorship apply. However, if you are a tenant in common with somebody and one or the other party dies, that tenant in common's interest goes to their heirs. It does not go to the survivor. So it might be probable that you might have to open an estate for the deceased. So that's going to impact your contract of sale. It's going to impact who signs, how title prepares the deed, what other research title has to do relates to whether or not an estate has been filed, proper documentation has been presented, and that type thing. If you're a sole owner, again, there's no one to whom those rights are going to pass. So you do then have to have somebody open an estate to convey the right of that sole owner to the new buyer. So how you hold title impacts the entire transaction. It's incumbent upon all realtors to know the effect of tenancy when you're looking at a deed so that you know how to have your contract executed, who has to sign your contract, and subsequently who has to sign the deed. What we have to remember is that real estate is linear in that it runs in a line. If it's wrong on the listing contract, it's going to be wrong on the sale contract. The sale contract is what title uses to try to determine from the onset, from the very beginning, who the players are. And then title pulls the deed and finds out the players are totally different because somebody died, there's an estate needed. That's going to impact your timelines, perhaps. So it's important that you do understand these tendencies and how they impact. I always urge all agents to go into the land records. Again, it's a free public website. Find the deed for the property that you're taking a listing on, or even the property that you're going to be representing the buyer on. Read the deed just to see if there's any flags there that come up for you, or if you don't understand the deed. Reach out to title and ask title to explain it to you to see what kind of flags may be there and how you might be impacted.
Let's say it's an LLC, and just one. Is that considered a sole ownership?
Yeah, an LLC is an entity.
Even if the LLC has more than one member to it.
Yeah. An LLC is an entity much like a corporate entity. It's a limited liability corporation, basically. So it just says these members are members of this corporate entity. So your seller, your owner, is that LLC. It's not the individual members. It's the LLC itself.
Right. And now the LLC, if you're going to deal with a property that has an LLC, you would need the articles of incorporation.
Yes.
If nothing else, to say the person who is signing, are they a member of the LLC, and do they have the right to sign? And what other reasons would you need it? Right.
So the articles of incorporation tell us that the LLC has been formed and filed with the state, that it does exist with the state.
So it does have to be filed with the state.
Yeah. The LLC has to be filed. We prefer that it be in good standing, but the LLC filings of organization do not tell us who has the authority to sign on behalf of that LLC. For that, we need a resolution or we need the operating agreement. So the operating agreement will tell us, okay, this LLC is owned by these 3 members. Of these 3 members, Ron is the member that we appoint to act on behalf of the LLC as it relates to the sale of this real estate. Or alternatively, additionally, we'll get a resolution signed by those 3 members saying we appoint Ron to act on our behalf of this LLC for this transaction.
So, and so if Ron signs to sell the property and later on the other 2 members say, we didn't want to sell that, if the documents that you've just cited indicate that that person had the right to sign for the corporation, then it doesn't matter what the other people have to say.
Well, that's why we require the document, because those other 2 people would have had to sign it. They, as members of that LLC, would have had to sign saying, we are the members. We had a meeting. Within the body of that meeting, we had a discussion about who was going to represent. And within that discussion, we appointed Ron. All 3 of them sign it. So we require that in our file just for that reason. So that should one or the other of them come crawling out of the woodwork 3 years from now and say, no, I never agreed. Well, I have this piece of paper that you signed. Did you or did you not sign it? Now, at that point in time, another discussion could be had. Well, no, I didn't sign it, but we can't know that because we don't normally participate in that part of the discussion. It's a discussion amongst the members, and then the documents are signed and then delivered to title. But that's exactly why we require that document.
Another thing that comes up is how quickly the deed is filed. Especially can happen with investors who want to purchase, renovate, and resale, and they want to do it as quickly as possible. So they buy a property, they go do all the proper title stuff, but it doesn't necessarily get filed right away. So 3 months later, they're saying, "I've renovated it, I've got it back on the market, I've got a contract." The next title company looks at it and says, "Well, it says Joe and Mary own this house, not you, Oliver. What's going on here?"
Right.
And of course, you tell them what happened. So what do you do when that happens? Do you say, can you provide the previous documentation from when you sold it or bought it?
From a title perspective, we cannot convey until we see that deed on record. Jurisdictionally, it's a crapshoot as to how long that's going to take. So in some jurisdictions, it could take from the time that you purchase the home, title gets it on record. It could take somewhere between 2 and 3 months before you see it on record. In some jurisdictions, it could take 6 or 8 months before you see it on record. It has to be visible. We have to be able to see it. It has to be, registered in the land records. Now, we will reach out to the other title agent and inquire, when did you send it down? Did it get rejected? Is there any reason for us to think there's any kind of further delay? And we work together with them to the extent possible, but we have to be able to see it because we have to refer to it in our new deed. And we have to refer to the recording reference in our new deed. So that's part of the structure of the deed to be able to say, this seller acquired this property by way of this deed recorded in this land record in this particular book and page. So we have to be able to see it. It's a problem, and particularly right now, Baltimore City, as many of us within the industry know, Baltimore City is probably 8 or 9 months behind.
Well, at least they're still using that excuse.
Well,
there was a pandemic, and
yeah,
sure,
yeah.
Well, whatever the case, we know that they are behind.
Yes,
and we'll give them the benefit of the doubt.
Exactly.
And say,
most jurisdictions are catching up very well, and they're back to their normal 2 or 3 months.
Yeah, well, since the market slowed down a bit, there's plenty of time for them to catch up.
We can only hope.
Well, actually, we don't hope the market stays slowed down, but
no, but we hope that they catch
but the
up.
other end of it,
exactly.
yes.
Yeah, exactly. Yep.
Okay, so they do. It actually does have to be recorded.
We have to be able to see it.
Another thing that happens is, let's say somebody is using an FHA loan to purchase the home. Even if it has been recorded, there may be a certain period of time where FHA says, they have to own that house for 3 years before we can give the loan on it.
Right.
I don't know why they have that ridiculous rule, but they do.
I don't think it's a 3-year rule, but there is a timeline.
Or 3 months or whatever it is.
Yeah, it's like 90 days. That is a valid rule. From a consuming public perspective, I think that is a valid rule. FHA says, in their way of thinking, I think, you're an investor. You went in and you purchased this home and you rehabbed it. And it took you a 30-day, or rather a 90-day time period to rehab it, pull your permits, get it all done, get inspections done, etc. That makes perfectly good sense. What doesn't make sense is, I'm an investor. I bought the home today for $50,000. I'm going to sell it to you, Mr. Buyer, 2 weeks from now for $150,000. Well, I certainly did not have time within that 2-week time period to do the work, get the permits if applicable, get inspections if applicable. There's no way that could have happened. It just doesn't make sense. So that's why that rule is in place. It's to protect the consumer. Now, but getting back to your question.
It can protect against illegal flipping.
There's nothing wrong with flipping.
There's nothing wrong with flipping,
illegal.
but illegal flipping would be where somebody pretends that the house has had numerous renovations.
Yeah.
When in actuality, maybe they just came in with a spray painter and made it look nice.
Right. They slapped some lipstick on the pig. Yeah.
A way where someone could actually get these renovations done in a quick period of time is if they start the renovations while it's under contract.
Which is risky for them.
Well, it's
because
risky.
They don't own it.
It is. That's true. But some will do that.
I know.
And so a lot of the renovation gets done so that as soon as the ownership becomes theirs, they're almost done.
Yeah.
And they're ready to turn it around.
Yeah. So again, lenders are going to want to see that deed on record. So you're still faced with the same problem. If the buyer's taking an FHA loan and your deed isn't on record yet, you're just going to have to wait, because the lenders want to see that deed. We have to tell the lenders in our title commitment to the lender, we found the deed into the seller recorded in the land records in this book and page.
Right. I still question whether or not FHA should be making such a rule.
Yeah.
Because either the renovations are done or they're not done. Either the property's worth a certain amount of money or it's not worth a certain amount of money. And it's not like the buyer doesn't have the right to bring an inspector in. It's not like the lender isn't going to send an appraiser in there.
Right.
There are other safeguards that say, we have people looking at it. Yes, it's worth that much money. And it could be, for whatever reason, maybe that investor just got a super good deal.
Yeah. I don't disagree with that necessarily, but I do think that it's better to err on the side of caution as it relates to protecting the consuming public than not. 90 days is not enough.
Well, it's the consuming public, but there's also the public in general. And the seller is a part of the public also.
Agreed. Yeah. We have that fight later.
And we're messing with their livelihood.
No question. Yeah, no.
Anyway, that's not up to us.
Exactly. That's not our problem.
we just have to abide by whatever laws somebody else put out there.
Exactly.
And that's the way it currently is.
We don't make the rules, but we have to follow them.
Right. So do you ever find anything on the deed that shouldn't be there? There used to be, people would put statements to prevent certain types of people from moving into a neighborhood.
Yep.
Obviously, things that are not legal.
Yeah.
Do you still see some of these things on?
Once a document is filed in the land records, it doesn't get amended, generally, unless they do a separate document amending said document. So, you'll still find deeds that have restrictions as it relates to race, religion, ethnicity, that type thing. But because those things are no longer valid from a legal standpoint, we ignore them. So they just don't exist legally.
So when a new deed is prepared, the title company actually prepares that deed.
Yes,
is that correct?
Correct.
And if there are those kind of illegal statements in there, that part of the deed, you can't transfer that part of it.
We don't bring that over into the deed.
Do you even have to bring it up?
Mm-mm.
Okay.
No.
Now, who signs the deed?
The seller.
And the buyer does not have to sign it.
The seller signs the deed to convey the property to the buyer. The buyer might sign attachments to the deed, for instance, stating that they are first-time home buyers or that they're going to occupy the home. The signing of the deed and the delivery of the deed to the buyer, it represents the transfer of title. That is the legal definition of transfer of title. execution and delivery of the deed to the buyer. So the seller is the one who signs the deed.
And what are the things that are in the deed are the people who own the house. They would be what, the grantors?
Yep.
And the grantee, which would be the buyer
Yep.
who's buying it.
Right.
The property
Yep.
and some description
Yep.
that says this is what the property actually is, which maybe has those meets and bounds type descriptions in there, or it'll probably then say or referred to as 123 Main Street, whatever,
Right.
How most people know it. And the price would be in there.
Yes.
And those are the basic elements that are in a deed, or what else am I missing there?
So no, actually that was a good recitation. The only thing you were missing is how the parties take title.
Okay. So if it's fee simple, or if it has a ground rent,
Fee simple versus ground rent, or alternatively,
tenants in the entirety.
Exactly. How they actually took title. Did they take title as tenants in the entirety, joint tenants, tenants in common? That is critical to the components of the deed. So we need to know how they took title so that moving forward, if they should choose to sell, we know how that ownership interest needs to convey.
Let's move to another part of the title, the settlement statement. Settlement statement is a good generic term for it, but it's been called the HUD-1 or ALTA, whatever ALTA stands for. What goes on the settlement statement?
So you had asked me at a point in time, what is the difference between an HUD, an ALTA, and a CD? The CD is the closing disclosure, which is used by lenders, which is prepared by and presented to the borrower to tell them how much money is being charged to them by whom, for what services, how much money. It basically outlines the entire financial transaction. What's your sales price? What's your loan amount? What's your down payment? Are you reimbursing the seller for any taxes prepaid or homeowners association fees prepaid? How much did you put as a deposit that we can use as a, offset towards your closing cost at the end? And it will tell the consumer how much money they need at the end of the day on the date of closing, how much money they need to bring to closing. The closing disclosure also incorporates their truth in lending disclosure statement, as well as a couple of other documents that used to all be separate up until the time that they started using the closing disclosure. So that's the norm. That's what you see more often than not, day after day. If you're dealing with a residential real estate where there is a loan involved, you'll see a closing disclosure. If it's a cash transaction, you're going to see a HUD. The HUD is old school. It, again, relays the entire financial transaction, but it's a very simplistic form. Basically 2 pages that says buyer pays this, seller pays that. Buyer owes this much money at closing, seller gets this much money at closing. It doesn't have all of those other disclosures included as part of the document. So that document is used basically for investors or for cash transactions. Closing disclosure, residential real estate, lender involved. The ALTA is a document that was created by the American Land Title Association, which is created specifically so that all parties in the transaction have one document that can be shared amongst them that, again, relates the entire financial transaction between buyer and seller. The closing disclosure contains a lot of private, privileged information that is only useful to the buyer and should only be given to the buyer. So that's why we in the industry created the ALTA settlement statement for use by others as part of who are involved in the transaction, for instance, the realtors and that type thing. So those are the 3 different documents that are used, but they all essentially do the same thing. They outline the financial transaction. They determine who owes what to whom, how much money is to be collected at closing, how much money is to be paid out to the seller at closing, commissions paid, that type thing. From those documents, then, title will, after having received all of the monies needed from both lender and buyer, and sometimes seller, but not very often, we'll put that money into our escrow account, and then based on instruction and the closing disclosure, we then disperse the file. We disperse out the seller proceeds, we disperse out the commissions, we disperse any funds that might be due to the clerks of the court for the recordation costs incidental to getting the deed of trust on record. We disperse the payments to the mortgage lenders to pay off any existing loans, any liens that have to be paid from that closing disclosure. We pay those out. So we pay out everything until we get to a zero balance. Whatever we collected on that closing disclosure is dispersed off of that closing disclosure. We take in the money, we disperse the money out, we get to a zero balance, and then our file is completely dispersed. So that's the role of title. It's title's job to do that, to disperse those funds in accordance with the closing disclosure and the instructions given to us by the lender.
Nowadays, it's not something that we see too often where somebody can bring a check to closing.
What you're talking about, Ron? We don't use checks.
People don't even make checks anymore.
Right.
but so basically, people are wiring the funds
Correct.
to you.
Yes.
Of course, the lender does that.
Yes.
It's interesting. Banks they wire funds all the time. I don't think they ever actually touch money, and that's
They
their
don't.
business.
Yeah. Right. Exactly. We never touch money.
Right. So, is there any situation where you could actually have money? Let's say something changes at the last minute and it's $100 here or there. Can somebody write a personal check for some small amount like that?
Yes, absolutely. Yes. So the reason that we have to take wires nowadays is because we have to have what is called good funds, meaning that those monies have to be available to us to use immediately upon receipt. If you bring me a cashier's check, I have to deposit that cashier's check. It has to clear my account before it is posted to my account and becomes good funds.
So even though it seems to be good, it's not good to you until you actually have the funds in your account.
Right.
And that might take a few days.
Correct. So that's why we require wires. Absolutely. You know, if we say to you, you need, or lender tells you, you need to bring or wire $25,000 to closing, and then something changes and you need an extra $500, will title take your check for $500? Absolutely. We will take a personal check for a sum of money, representative of a small amount of money. Every title agency has their own internal controls over up to what dollar amount will they take a personal check. And so that's going to be situational, depending upon which title agent, what the circumstances are, that type thing. But yeah, we'll take a personal check, but that's why we require wires.
Now one last thing, and there's lots of things that we could discuss here. Besides everything we discussed, the lender is going to send you, you can't see it in the video here, but actually our roof actually retracts and opens up. And typically what happens is a crane moves in and drops like 3 tons of paperwork on the table.
Fact. Yes.
And so when the buyer and the seller get there, mainly the buyer, especially if they have a loan, they say, I got to sign all those papers.
Yep.
Well, give a quick summary of all this paperwork.
So it's a lot. Quick summary. There are some internal documents that title uses. For instance, we create, as you know, the deed. We also have some affidavits that we have the seller sign, acknowledging that they do own the home, that they're 18, that they had no judgments that we couldn't find, a number of different affidavits. The lender's package includes such things as the note, which is the promise to repay the loan, the deed of trust, which is the document that we record in the land records to give reference that there is a lien against the property. The lien is the loan that has been taken by the buyer. There are other documents that the lender has internally that they need to have signed at closing. Additionally, there are some tax documents that need to be signed at closing that the lender supplies, which would enable, in the event it was needed, for the lender to confirm the tax documents that are on record with the state and federal government, to report the interest amount paid each year by the buyer. So there are some additional documents there. So it looks like a daunting stack, but we get through it pretty quickly.
I understand that there are some documents that previously used to be, you had to sign them at the table, but they can be, you can send them to people online and have them sign some of them require the wet signature, but there are some documents that aren't as important, I guess.
Right. Some lenders are now offering hybrid closings where you sign, you're the consumer, you're the buyer, you can sign some documents electronically, and then you would come to title and just sign just a smaller stack of documents, which would include, For instance, your note, your deed of trust, whatever has to be recorded, whatever we need a live signature on, as they say. A number of the documents that come to closing could be e-signed if the lender participates in that hybrid or e-sign platform. Not all lenders do, but those who do, they do make it a lot easier for everybody. So that's coming. We will never get to a point, I don't think, where we will be 100% electronic, mostly because the deed of trust having to be recorded. The clerk won't take an e-signature. Well, I'm not going to say that across the board. We're not currently seeing e-signed deeds of trust filed in the land records. So we're working toward that end, but by and large, unless your lender participates in that hybrid platform, they're going to be signing these documents live at closing. But more and more lenders are going to the hybrid platform.
And you yourself, you're also, besides the title person, you're a notary.
Correct.
So you are witnessing these as a notary.
Correct.
That is a requirement for many of the documents.
Correct. So as a title agent, I have to be a notary, mostly because I have to notarize all these documents. But additionally, in order for me to do the closing, if we're offering title insurance, I have to be a licensed title agent. So there are some things that I'm required to be, have in place as well. So the notary is the title agent more often than not.
Okay, well let's wrap it up with that because we have gone for quite a bit.
Mm-hmm.
There's a lot of information that we've gone over here. There's more information that we could go over. So if anybody wants more information, or if you actually need the services of a real estate agent or a title person, you can certainly call us. Again, I'm Ron Trzynski. I'm with Sachs Realty, and you can reach me at 410-935-5844. And Charlene, you can let everybody know who you are again and a contact number. That's fine. You can give that.
Thank you, Ron. And again, thank you for having me today. It's been actually a pleasure and a lot of fun. You can reach me. My name is Charlene Perry. I'm with Broadview Title. You can reach me at 443-512-8450. I'm always happy to answer your questions. I'm always happy to assist you if you're having difficulty finding a deed or something. So please feel free to reach out.
All right. Thanks, everybody. Have a great day.
Sachs Realty, Maryland broker number 607720, office number 443-318-4514, equal housing opportunity.